Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And it's good to be back with you again. It's been a while since we've did one of these little one-on-ones updating you on litigation or things of that nature, but that's what we'll be doing today. And specifically what I have reference to is the litigation regarding former Louisiana State Police Commission Executive Director Kathy Derbonne. Now, just for a little bit of background for those who are relatively new to the Sound Off list, way back in January of 2017, I was encouraged to come to videotape my very first meeting of the Louisiana State Police Commission. I did not know up from down regarding it, but I will say that on that January of 2017 meeting, the feature item on the agenda was an item which was so labeled, the consideration of the continued employment of the executive director, Kathy Derbonne, as well as an assessment of her professional competence. So I walked into that meeting not knowing, what was what, or if this lady was, I'll be honest, I wondered, well, did she steal something? I did not know who was what or what. Now, as was evident in that very meeting, it just didn't take rocket science to start to put some of the pieces together of what was transpiring here. But at any rate, in a nutshell, and it made the Advocate and the news at that time, the Louisiana State Police Commission went into executive session, and by all accounts, led by Governor Edwards as a super PAC head, T. Taylor Townsend, whom the board had hired to deal with some matters, basically strong-armed Ms. Derbonne into resigning under the premise that if you don't, it's going to get ugly out there. We'll embarrass your family and everything. Now, with regard to what they would have made such an embarrassment, I don't know. I can only tell you that a resignation letter was rapidly thrown together. It was about 2 sentences long. There was a misspelling in it even, and she quickly signed the resignation letter that was pre-drafted basically for her, and then the meeting continued after executive session with her no longer present and no longer serving in official capacity as executive director. Now, close to a year later, Ms. Derbonne filed a constructive discharge lawsuit in which she alleged that she was constructively discharged as a result of quite a few items of whistleblowing activity that she had engaged in. Now, you didn't see it from the mainstream media, nor will you ever see it, but we did a feature toward the end of January of 2018, and we highlighted most specifically paragraph 17 of Kathy Derbonne's litigation. In paragraph 17, and we've got it blown up for you just beneath this video, and I'm going to read it to you at this time because I found that to be the most striking paragraph of all of the litigation. So I'm just going to read it off to you. Now, I will say this, and we've notated it below the paragraph. There was a typo in there. The date, it says, is on July 19, 2017. That should be 2016, okay? July 19th of 2016. In other words, we're talking about only 6 months after Governor Edwards has taken his hand off of the Bible, swearing to uphold the Louisiana State Constitution, all right? And if you go back, we're providing you with a link of the original feature we did. You'll see video of him taking that oath of office and swearing to uphold the Constitution for the state of Louisiana, which is why paragraph 17 is so interesting. So I'm going to read it with that corrected date in there, even though it'll say 17, we're going to read 16 because that's what it should be. Paragraph 17 says, on July 19, 2016, during a telephone call with the chairman of the Gaming Control Board, who is Ronnie Jones, the DPS General Counsel Blackburn, who is now deceased, and Deputy DPS Counsel Williams, while petitioner, that's Derbonne, while Derbonne was present, but unbeknownst to the gaming board chair, that'd be Ronnie Jones, he, being Jones, stated, and I quote, and we've got it highlighted, and I'm quoting now, the governor's office had told Derbonne, it says petitioner, had told Derbonne to, quote, shut the F up, unquote, after Derbonne had previously complained about the unlawful constitution of the commission. In other words, she was saying that these appointments that Governor Edwards has made, they don't follow Louisiana's Constitution, which is why I pointed out how ironic that would be, given so early into his term after he put his hand on that Bible and swore that he would uphold the Constitution of the state of Louisiana. And it's particularly also further demonstration of a mockery of the so-called honor code that he touted so much in 2015 that we're not hearing a whole lot of for 2019, but I do see he's run a recent ad featuring the West Point. We're going to have quite a bit more to say on that in the subsequent feature, in fact, a couple subsequent series of features. But for now, let's go on. So Derbonne files her lawsuit. Now, the Attorney General's office is tasked with defending any state agency. It's one of the key roles that the Attorney General's office has to fulfill. And so Jeff Landry at the Attorney General's office retains an assistant special attorney general to handle the matter, as is so often the case. Most of it is subcontracted out. And so basically, well, they filed a peremptory exception of no cause of action. And what they largely stated in there is that, look, you've made a whole lot of allegations in here, but none of them directly pertain to the Louisiana State Police Commission, which is the body that you're suing. So they filed a peremptory exception of no cause of action, saying that our client, basically the commission, didn't do anything wrong here. A lot of other people may, most specifically Governor Edwards and former LSP Colonel Mike Edmondson, but you can't blame that on us nor hold us liable because we're not the ones that did this stuff, okay? So the court hearing was held in February of 2019. That's February. Now, we went for 13 months. There was never a court hearing on this trial. And then in February of this year, we had the hearing on that peremptory exception. As we tend to do, we attended that, as we attend so many court hearings and then report to you of them. Judge Morvan, who is the judge who was assigned this case, he did concur with that logic that, in fact, Judge Morvan said it himself. There's a whole lot of allegations in here about a whole lot of folk, especially the colonel, former colonel, that being Mike Edmondson, but you haven't identified an act that was committed by the Louisiana State Police Commission that would give you a cause of action. And so he granted the peremptory exception, and he also gave the obligatory 30 days in which Ms. Derbonne was afforded the opportunity to amend her petition. And operating through her attorneys, Jill Craft and her Craft Law and the Craft Law firm, she did amend the petition. And you may remember not long back when we did a summation of about 5 or 6 lawsuits involving state police or state police related entities, we stated that it was a virtual certainty that the police commission would reassert its peremptory exception. And they certainly did. And thereafter, now the stage that we're at is the ball's back in Ms. Derbonne's court. In 8 days within 8 days of the hearing, you have to file what's called an opposition memorandum to the latest reasserted statement of no cause of action. Ms. Derbonne, acting through her attorney, did make that filing on July the 19th. Which was 1 week ago today from the day I'm filming this, because the court hearing, it will be in Judge Morvan's courtroom on Monday, July the 29th, and we will certainly be there, and we will update this feature for the outcome. But I want to take just a few moments today. We're giving you the entirety of the opposition memorandum, and I would welcome you to read it. But I'm just going to take the time to look at a few highlights. Like I said, you're welcome to read the entirety of the opposition memorandum. So let's start, and I'm just going to really read the highlighted material. We'll begin with, it was determined that numerous state police commission members, including then Commissioner Kyle, Member Goldring, and Member Pitcher, engaged in political campaign violations. The commission deliberately failed to take any action against the members as required by law, and as a result of the commission acted, in derogation of the law. Which is going to be an interesting argument. What they're saying essentially is that I don't have to prove they did something. They had an obligation under the law to investigate Miss Derbonne's whistleblowing activity, and instead of investigating those activities, they took out action against Miss Derbonne. That's what we talked about, bringing her into a little closed door and said, now look here, you're going to resign, otherwise it's going to get pretty ugly out there. It will not be pretty. And so the next little highlighted section that I want to focus in on, it says the State Police Commission Rule 2.4 and 2.9 charges the Commission with the mandatory duties to investigate allegations of misconduct, hold hearings, and render orders when violations of its rules occur. The State Police Commission's failure to do so violates the Louisiana Constitution, its own rules, and the law. All right? Once again, reinforcing, hey, I'm not gonna say you did something. I'm gonna say you have failed to do something. All right? It's an interesting little twist here. Now, I want to focus in on the next highlighted segment. It says, quote, she was made aware of a classified state police trooper facilitating a vote to each troop station endorsing a particular gubernatorial candidate in violation of the law. Although these members violated the applicable State Police Commission Rule 14.2, the Commission took no action against them, even though the Commission was obligated to do so under the law. Now, I want to focus in for just a moment about endorsing a particular gubernatorial candidate. Now, I see no need to be so vague. All right, let's cut to the chase. Who did they endorse? He would be our current governor, John Bell Edwards. So I don't know why there would be a need to tiptoe around this. Everybody knows who's being referenced here. It is current Governor John Bell Edwards. All right, so let's go to the next little highlighted section. On or around August 11, 2016 timeframe, plaintiff was advised that Edmondson and at least 4 of his top deputies had received pay increases of as much as 32% without authorization and in violation of the law. Now, I would submit there's plenty that was in violation of the law under the Edmondson regime, and you want my opinion? Not a whole lot's changed under Reeves. I'm going to just be blunt about it. I'm not going to get off on that tangent. You're welcome to go back and look at the alleged nepotism regarding Colonel Reeves' son and who all approved that, and I'll stop at that. But I don't think there's been much of a change at all. There may be a little pretty choir boy image out front. That's even more dangerous. Edmondson certainly didn't present the pretty choir boy image that Reeves does, but in my opinion, that makes Reeves even more dangerous. All right, now, going down to this next highlighted section. Chairman Doss ignored her complaints and refused to act, which is a derogation of Louisiana law. During a November 10, 2016 commission meeting, plaintiff was specifically asked about these pay increases, where she advised they must be properly approved, otherwise they were unlawful. Now, and as you'll see, we put a little blown up photo there. This actually caught the attention of the mainstream media, and you see the headline there, State Police Colonel Edmondson lands hefty raise along with several other top officials. And if you'll notice, Edwards, what sign's in the background? Governor John Bell Edwards. Every bit of this took place on Edwards' watch, okay? All right? You're not going to be able to blame all this on Jindal. Jindal's got plenty enough blame that he is entitled to, but it was your decision, Governor Edwards, to reappoint Edmondson, and now we're being told that you're telling a whistleblower, or your office is telling a whistleblower to shut the F up. Only months after raising that hand that I'll uphold the Louisiana Constitution. And what she's saying is you didn't uphold the Constitution, but you're telling her to shut the F up, or someone in your office is. It very likely may be Matthew Block. It really doesn't matter. If it came from the governor's office, it is representative of Governor John Bell, Honor Code Edwards. All right. The last part we're going to focus on, and obviously we will give you the results of the court hearing. There's this argument that, well, Governor Edwards is not her employer and this, that, and the other. And Bruce, the gentleman that drafted the opposition memorandum, although there was the same verbiage in the reasserted peremptory exception, I'm sorry, in the amended petition, they used the Murphy-Painter case in saying that the Alcohol and Tobacco Control Commission, while it's, look, ultimately everybody's accountable to the governor. The governor appoints every one of those board members with the exception of one, which is elected by the troopers. And so what you're seeing next is an argument that, don't tell me this wasn't her employer. She's an employee, of the state of Louisiana. All right. So let's read what it says. Hence, the definition of employer. I scrolled down a little bit too much. The definition of employer is given the broadest application. The principle is important because, as she alleged in paragraphs 1 and 2, plaintiff's, quote, employer, unquote, is the state of Louisiana, which includes the governor. And let me tell you something, anybody who's ignorant enough to think it doesn't is naive beyond words that I could ever possibly come up with. Okay, it's that simple. It's a throwback all the way to the Huey Long days. Nothing has essentially changed. And if you are naive enough to believe that the governor doesn't carry a lot of weight and does a lot of things with regard to individual positions, then how to phrase this? Maybe you were born last night. Let me put it that way. So there is some more material in there, particularly with regard to what is alleged to be the illegal appointment of Jason Starnes to the de facto, he's not given the title, but he serves in that capacity, the de facto undersecretary. And I'm just going to say this, and we're going to give you the video for it. In all of Sound Off Louisiana's meetings that we've gone to, that we've videotaped portions of, never has there been a more hostile exchange than transpired between then Commissioner Lloyd Grafton and current Commissioner Jared Rickey. Now that video's been viewed a little over 1,800 times as of my checking of it a moments ago. If you haven't seen it, I'd recommend tuning in. As you can tell, there was quite a bit of controversy about this particular hiring, and it spewed over pretty tersely between those two particular commission members. So basically, here's the situation. As I said, Judge Morvant granted the initial peremptory exception. He also gave the obligatory 30 days to amend the petition. And by the way, the defense attorney said, Your Honor, I don't see how you cure this. Judge Morvant did interject that he didn't agree with that statement. And so we have a amended petition. Then you have the reasserted peremptory exception. And now we've got what is a pretty interesting argument that I'm not going to substantiate that you did anything. You failed to do something that you were required to do under the Constitution. Thereafter, you took retribution against my client for her whistleblowing activities. This is going to be an interesting ruling for Judge Morvant to have to make. If I'm on the defense side, I'm going to have to consider throwing out the argument that, well, fine, if Governor Edwards is considered her employer, why wasn't he named individually in the lawsuit? Now, if Governor Edwards is named in the lawsuit, it probably garners a little bit more, well, let's get to the chase, quite a bit more attention. Perhaps even the mainstream media can't resist running with that one. But since he's not, it's relegated down to little old folk like me, your pesky little blogger. It is amazing to me that you can have a paragraph in a lawsuit that says that his office has told her, and remember, there are going to be corroborating witnesses that were in on this, even though Frank Blankbird is dead. Others are not. And so this statement that Governor Edwards' office, it might even be Edwards himself, who knows who said it. If I had to put money on it, I'm going with Matthew Block. That fits his modus operandi to make just such an utterance. I told her to shut the F up. Well, Matthew Block, for all intents and purposes, it basically is governor. Okay, Edwards just holds the title. So for a remark like that to be made, that's incredible. All right. But what's even more incredible is you don't even see the first mainstream media outlet that's ever had got enough to touch it. And as Moon Griffon will quickly tell you, they're not going to either, because John Georges now controlling the Advocate, the Times-Picayune, and no doubt he's going to make a launch for the other publications. And you got the Lake Charles fellow, I can't even remember, Jim Bean, I think. Anyway, Moon will let you know real fast how much objectivity you're going to get there. So you got it here. The statement was allegedly made, and we're going to update this feature to let you know if Judge Morvan, if he grants the peremptory exception, I guess you could kind of say he too has said, now look, you need to shut the F up. Although I don't think any one of the judges up there would lower themselves to that level of bluntness. But we have allegedly the governor's office, who was more than willing about a matter involving them in campaign contributions and unconstitutional appointments to a commission, to say, shut the F up. Folks, we look forward to updating this feature at the top and letting you know how the ruling goes Monday morning in Judge William Morvant's courtroom. And I'll conclude with this. Some folk have asked me, well, you sure you've been quiet as a mouse about the governor's race. And I'm not going to lie, I'm not very happy with the way this race is going, and in particular the approach taken by the two Republican candidates to try to win this thing. But I'll let it go with that. We will begin, hear what I'm saying, we will begin releasing weekly, very short clips. And when I say short, I mean 2 minutes, 2.5 minutes. We're going to release them on Tuesday of each week, God willing that I'm not ill or something. I think you'll find them very interesting. So stay tuned for the weekly Tuesday features entailing the 2019 governor's race. So this is Robert Burns thanking you once again, and we look forward to bringing you the next edition of Sound Off Louisiana, which will be that first Tuesday release entailing the governor's race. Thank you once again.